Hi, this is Steve Basche, and welcome to the first of what I hope will be a series of videos about probate in Connecticut. I thought it would be a good idea to start off with kind of how I handle my initial probate consultation. And the first thing we need to do is to determine what type of probate we're going to be involved in. Uh, and we'll talk today about the three different types of probate: affidavit in lieu of administration, tax purposes only, and full probate. First, I think it's important to get an understanding about uh, probate versus non-probate assets, because the term probate assets is something that we use throughout this conversation, and it's important to understand that probate assets are assets that are solely owned and have no beneficiary. So those are the assets that have to go through some sort of a probate process to be distributed. Non-probate assets, on the other hand, are things that have beneficiaries or have co-owners, and those don't have to go through the probate process to be distributed because they have a beneficiary, and uh, whoever the beneficiary of, say, life insurance or a retirement account is going to get that asset regardless of what the will says, um, and without having to go through the formal probate process. So probate versus non-probate assets. Non-probate assets have a beneficiary or have a co-owner. Probate assets are solely owned and have no beneficiary. One of the most common questions I get is there some sort of a simplified procedure that we can use for a small estate? And luckily, the answer is yes. But unluckily, it doesn't always seem that it's going to be available because of the dollars that are involved. This option of probate is only available for situations where the assets are under $40,000. But if you've got a situation where there are solely owned assets less than $40,000, maybe it's a car, maybe it's a tax return, maybe there's some checks that have come in, but everything else is non-probate assets. We can use the affidavit in lieu of administration process to handle those probate assets. And the process involves filing the affidavit in lieu of administration, which is the PC 212, along with a couple of other forms. And it basically lists at the top, what are the assets in the estate? Is it a checking account? I mean, is it a check? Is it a bank account that's solely owned? Um, or is it a motor vehicle? And you list those assets. And then on the second part of the affidavit, you list the expenses of the estate, and you go through, and if there's excess money, if the assets are greater than the expenses, then you ask the court to order a distribution of those assets, either in accordance with the will, if there is a will, or if there's not a will, um, in some other fashion, um, basically in accordance with the laws of intestate succession. And sometimes there are variations of how the assets get distributed through the order of distribution. If the assets are insufficient to pay all of the claims, so there's not going to be any money left over, then it's a matter of just listing those claims and saying who paid them, and if they haven't been paid, then asking the court to order the transfer of the assets in order to pay those expenses of administration, such as funeral expense, reimbursing someone who's paid the funeral, legal fees if there are any, if there are outstanding medical bills, things like that. So that form gets filed along with the estate tax return. And the estate tax return is a document that lists the total value of the estate, not just the probate assets, but the non-probate assets as well. So you can have an affidavit in lieu of administration with less than $40,000 in solely owned assets, but with 400 or 500 or $2 million worth of non-probate assets. And those assets have to go on the estate tax return. And just to mention, while we're talking about the estate tax return, the estate tax return is a document that is typically prepared by an estate and probate attorney as opposed to an accountant. It's not an income tax return. It's basically what's the total amount of the estate of the individual. The next option that we look at is whether the probate can be a tax purposes only estate. And a tax purposes only estate works if there are no probate assets. So no solely owned assets, no solely owned vehicles, no checks, no refunds. And it's basically just a matter of filing the estate tax return to prove to the probate court that the estate is under the taxable threshold, or if it's over the taxable threshold, to determine what the amount of the estate tax is. The current estate tax exemption in 2025 is $13.9 million in Connecticut and also at the federal level. So most estates are non-taxable because they're under that threshold amount. A tax purposes only estate is kind of our goal when we do a revocable living trust plan. So the goal is to avoid probate even on those assets that might otherwise be probate assets. For example, solely owned real estate. If we take solely owned real estate and put it into a revocable living trust, it becomes a non-probate asset, and we can avoid probate and just file the tax purposes only estate. So that's one of our goals there. And last, but certainly not least, is full probate. So that is probably the most common estate that we deal with. And even if it's just a solely owned home, that has to go through the probate process. And one thing that just occurred to me is that a lot of people think that if they have a will, they avoid probate. That's not the case. A will is your written instructions to the probate court about who you want to handle your probate and how you want your assets to be distributed. Having a will does simplify probate because you can specify who you want to handle things, how you want them distributed, waiving certain bond requirements. So it is a better idea to have a will, but it doesn't avoid probate. So the full probate process involves submitting the will, if there is a will, to get the person named in the will to be the executor. If there's no will, the person who gets appointed is called the administrator. Then once that person is appointed, there are a series of steps that we'll detail in another video that include filing an inventory, a return and list of claims, the estate tax return, a financial report, certificate of devise and descent, and a bunch of other, steps or things that may or may not be required in any given probate situation. This is a process that can take up to a year or so to complete, and sometimes longer than that. So thanks for watching this first video. Hopefully there'll be others. Take care. Bye.